About Senator Trillanes in my capacity basically as co-IC for the office of the president, right? More with that hat rather than with my hat as Secretary of Justice. Okay, so are we ready? All right, so our moderator Irene of our communications office, so you can start now. Oh yeah, of course, our OIC Prosecutor General, merong instruction ng Presidente rin sa kanya under this proclamation, right? Prosecutor Dong Alunyo. I'm sure you've met him. Matagal na siya rito sa PH.
Ulo. Cellphone.
Statement regarding this particular
Opening statement.
Yes, sir. Could you explain the
All right, okay,
slide, sir?
Okay. Go na. Magandang tanghali po sa lahat ng nanonood at sa kanilang mga television sets at mga nakikinig sa radyo. Pinagawa po namin ang press conference ito para masagot ang maraming katanungan na may kinalaman sa proclamation na inisyu ng Presidente na sa pagbaliwala ng amnesty proclamation insofar as Senator Trillanes is concerned. So we are here to answer questions from the media. So may we have the first question, please?
Excuse me, can you just identify yourself?
Yeah, please identify yourself before
and
you
the
ask.
network where you know,
Right.
please.
Thank you.
Hi, sir. Sir, Anjo Alimar from CNN for you.
So you're Anjo. All right,
Sir,
Anjo.
can you walk us through the process? What went behind this proclamation? Kailan ito nag-start, sir, yung process of the...
All right. Yeah, we are talking about proclamation number 572, signed by the President on August 31, 2018. Just a couple of days before he departed with many members of the cabinet for Israel and Jordan. All right, this was also attested by Executive Secretary Mejaldea. And I was informed about it on the day of the departure of the President, verbally at least. And I got a hard copy of the proclamation, a certified copy, only yesterday. I understand that the proclamation was published in a newspaper of general circulation today, this morning. So I do not have any personal knowledge as to when the review of the amnesty given to Senator Trillanes actually began. But what I know is that this matter of review has been there for quite some time. It's not as if this happened only 5 days ago or nothing of that sort. I think this has been being discussed a couple of years ago, as far back as 2013, I guess. But it just so happened that now, it was only recently that the proclamation was issued by the President. Take note that the title of the proclamation is Revocation of DND Ad Hoc Committee Resolution Number 2, dated January 31, 2011, insofar as it granted amnesty to former LTSG Antonio Trillanes IV. All right, so while the title indicates that it's a revocation, the contents of the proclamation, if you have read a copy of that proclamation, would show that it actually nullified or declared void ab initio. All right, the issuance of the amnesty to Senator Trillanes, as if it never existed, never been valid for non-compliance with certain mandatory requirements for the availment of that amnesty. So, binaliwala ito as if it never existed. It's not, something that was given and being taken back. All right? It's a declaration that it was void from the moment that it was issued. Next question.
What makes it Ina reforming, sir?
Yes, Ina.
Sir,
Right.
what makes it different from the amnesty granted to the other Magdalo officers? Basically, entirely the same circumstances.
Well, the proclamation speaks of certain non-compliance on the part of Senator Trillanes with requirements for the grant of the amnesty. You will take note that there is mention of proclamation number 75, series of 2010. So that is a general proclamation of amnesty to those who were involved in the Oakwood Mutiny, the Manila Peninsula siege, and Marine standoff, no, on various dates, several dates yon. But to be able to implement that grant of amnesty, merong kinreate yung proclamation na yon na ad hoc committee sa Department of National Defense to accept yung applications, na individual applications for amnesty. So may mga basic requirements. Two of the most notable requirements, and this is apparently were not complied by Senator Trillanes, ay yung formal pag-fill up in person under oath of an official application for amnesty. And the other major requirement is that he should have admitted fault, all right, or guilt doon sa mga charges na filed against him. There must be an express admission of guilt, all right, before you can be eligible for amnesty. All right, so apparently based on the review undertaken, ay hindi siya nag-comply dito. As a matter of fact, there are allegations that to the media he said na he does not admit any guilt of the offenses charged. No? Take note that for purposes of amnesty, we are talking about high crimes, political crimes, such as rebellion, sedition, mutiny, coup d'etat. And he was in fact charged with coup d'etat in a regular court of law. Yes, please. Please identify yourself.
General Kuya po Bomborado. Sir, may ba't kay Senator Trillanes may kasama po siya dyan?
For now, the proclamation only covers him, no. But I believe that maybe others who might be similarly situated are also yung kanilang applications might have are also being reviewed, no.
Excuse me, sir.
Not too sure about that, but I suppose that since there is a review ongoing, it might include not only Senator Trillanes but also the others. So,
Jeff,
hi, Jeff.
may interview yata si Trillanes kanina. Parang sabi niya, meron daw siyang certificate. So, ibig sabihin, nabigyan siya ng amnesty. Wala siyang, parang nag-comply siya sa mga requirements.
Well, let him just show it, no? What we're saying is yung requirement of an application under oath does not exist in the records, and that there are no records either of any admission of guilt on his part, no, for the charges filed against him.
Next.
Sir, Lian Buwan of Rappler.
Hi, Lian.
Sir, does the proclamation have an effect of a warrant or kailangan pong mag-apply ng DOJ ng warrant of arrest?
By itself, no, the proclamation directs the Department of Justice as well as the Armed Forces of the Philippines, no, to take the necessary action in order to continue the proceedings. Why AFP? Because apart from the criminal complaint for coup d'etat pending with the Makati Regional Trial Court, at the time of the issuance of the amnesty or of the proclamation granting the amnesty, ay meron ding court-martial proceedings ongoing before the Department of National Defense, no, or Armed Forces on the matter of the mutiny, conduct unbecoming of an officer, and so forth and so on. So meron ding parallel proceedings happening before the Armed Forces of the Philippines. Kaya meron ding directive addressed to the AFP to continue the proceedings against Senator Trillanes. So that will probably entail the issuance of more detailed orders, no? Like on the part of the prosecution, we will probably have to reopen the case that was filed before the RTC.
So, he cannot be arrested
The proclamation has directed all enforcement agencies to apprehend him. So he will be placed in custody. As to where that will be, that is a matter that we need to await a little. And maybe for now, if he's attending sessions of the Senate can probably put him under its custody in the meantime.
The issue on legislative immunity does not rise in this case.
It's not applicable. There is a provision under the Constitution that provides or gives members of Congress the privilege of not being arrested while Congress is in session. But take note that that will apply only if the offense charge is punishable by an imprisonment of not more than 6 years. So yun lang ang applicable yung privilege na yun. If the offense carries a penalty not exceeding 6 years. But coup d'etat carries the penalty of life imprisonment, and for that reason is non-bailable.
Joseph said it.
Yes, Joseph.
Sir, who conducted the review?
I am not sure who exactly conducted the review, but I suppose this might have been studied in the past by the Office of the Solicitor General.
Sir, okay. Does this have to satisfy the two requirements, the application and the admission of guilt, to be qualified for amnesty?
You mean if he will redo the whole thing? No.
Yung sa status na.
At that time, if he complied with those requirements, would he have been entitled? I guess the answer to that question is a definite yes.
Sir,
If he was given amnesty, notwithstanding that the requirements were not, strictly met, with more reason that amnesty would have given to him if such requirements were actually met.
So kasi in 2011, we had a report, we had video showing that he did apply, at least in first requirement, that he applied for an amnesty.
Then let him show it. But that is really beside the point, because there is this more important requirement of admitting one's fault, before one can be entitled to an amnesty. You must first admit your guilt for rebellion, sedition, or coup d'etat, as the case may be. Now, show proof that he actually, admitted guilt for such offenses.
Without that, sir, valid yung 572, no? Without that na proof na that he did admit to the crime, valid yung 572.
That's what the proclamation says, no? And upon review, and these basic requirements, mandatory requirements, were not met. That was the basis for a declaration by the president that amnesty granted to him at that time was actually void ab initio.
Why only specific to Senator Trillanes?
I am not saying that it's specific only to him. As a matter of fact, I said earlier that I have reasons to believe that maybe people similarly situated like as Senator Trillanes, the grant of amnesty to them might also be under review.
You talked about reopening the case on the part of the Department of Justice, which of course prosecuted this case before the Makati RTC, if I'm not mistaken. So from here on, what are we looking at, sir? How are we going to do about it? That reopening, and because the revocation so far only pertains to him, does it also mean that if we reopen that particular case, it will only apply to Senator?
First, we have to check our records first, okay? Because that case was filed and prosecuted way back in 2003. All right, so 15 years ago, and we really have to look at the records of the case, if the proceedings were merely suspended, or if there was an order of dismissal and stuff like that. So we need to find that out first. Maybe, all right, Prosecutor General OIC Fadulyon may be able to answer the question.
As far as he's concerned, he was accommodation.
Submitted or what?
The decision was about to be promulgated way back in 2010. However, the decision was about to be promulgated in 2010.
However, because of the manifestation of the defense that there was an application for amnesty or amnesty was being offered, the court suspended the promulgation. And it was supposed to have been subject to the compliance with all the requirements for application for amnesty. Now, as far as our records, the records that we've seen so far, there are among the accused who were actually, there was a decision which was rendered by an acting presiding judge who took over Judge Pimentel, and she approved the amnesty which was granted to some of the accused. But when I looked at the records, it did not include Senator Trillanes. So we're still in the process of looking at all other decisions of Regional Trial Court Branch 148 as to other decisions that may have been rendered as far as the other accused are concerned, sir.
So the applications were presented to the court pala, sir?
No, manifestations were filed with the court saying that the accused who had filed or availed of amnesty had complied with the requirements. These were filed by their respective counsel. So on the basis of that, the acting presiding judge at that time approved the said applications.
And it did not include.
As far as the order that I have reviewed so far this morning, it did not include the name of Senator Trillanes. But again, we're having our prosecutors in Makati check with Regional Trial Court Branch 148, check with the records to find out if there were other orders or decisions that were rendered pursuant to approving the amnesty applied for.
What does it mean? Promulgation of the in this case, it was already up for the prosecution and defense were already completed, and it was already up for promulgation.
Yes, the decision, the case was already submitted for decision. In fact, if I recall, Judge Pimentel already came out, scheduled it for promulgation, and he had with him a copy of the decision. He was just about to promulgate the decision when there was a manifestation from the defense counsel stating that there was amnesty that was supposed to be granted to all of the accused.
Sir, ibig sabihin nun na kanina wala dun yung application ni Trillanes sa RTC?
Kasi there are, if you look at the case, there are about 31. There are about 31 accused in this case. Now, if all of them availed of amnesty, then naturally there would have to be a manifestation to the court informing the court that they had complied with all the requirements. Apparently, not all of them were represented by one counsel. So, depending on who filed the manifestation, the orders would come out. Now, what I'm saying is that based on what I have checked so far, it did not include the name of Senator Trillanes.
So walang application?
Well, not in that order. It would appear that in that particular order, it would appear that as far as Senator Trillanes is concerned, wala pang approval. So we're checking other orders of the court.
If mabubuhay ulit yung kaso, sir, ibig sabihin, desisyon na lang yung kulang. Judge Pimentel, andyan pa ba?
Wala na po. Judge Pimentel retired already, I think, in 2010. Okay, so there's another judge, Judge Soriano, if I'm not mistaken, who is the acting presiding judge of RTC Branch 148. And you are correct. If the case will be reopened, it is only for the purposes of one, asking for the issuance of an alias warrant of arrest, and second, for asking the court to promulgate the decision, considering that the court had already previously acquired jurisdiction over the person of the accused.
Okay, sir. Do you need to apply for a warrant? Or you
Yes, sir.
Yes, warrant.
Ayusin mo. Alias warrant.
Alias warrant, sir.
All right. After the proper review of the records of this case, and we have determined that it's something that is ripe for reopening, all right, that there are grounds to reopen the case, then first order of the day will be simply to ask the court for the issuance of an alias warrant, so that the person of the accused will be brought into custody of the court. We'll do it as soon as we can, as soon as we find all the records pertaining to this case. You will please note that this case happened 15 years ago, so we'll just have to look into archives and other, case records on file.